One can hear me? Good. Good evening, everyone, and welcome to the Daniel Webster Debate Series. This series was named in honor of Daniel Webster, one of our nation's greatest orators, public servants, and advocates. Founded just last year, this series has already become the heartbeat of our chapter and a cornerstone of the intellectual conversation here in the nation's capital. By bringing together leading judges, scholars, and practitioners from across the country, we aim to engage the most pressing legal and policy issues of our time. Tonight's resolution, should courts adjudicate partisan gerrymandering, addresses a challenge that seems eternal in our republic, striking at the heart of our ongoing efforts to ensure our elections remain fair and free as possible. Questions of equal representation and even racial discrimination lie at the center of this debate, and questions that continue to occupy the attention of our Supreme Court. It is therefore my great honor to host this evening's program featuring two of the nation's leading experts in this issue, and to welcome the Honorable Judge Joshua Devine as tonight's moderator. So without further ado, please join me in welcoming our debates director, Louis Pham, who will formally introduce our three distinguished panelists. Thank you so much.
Good evening, everyone, and thank you for coming to tonight's debate. Our moderator is the Honorable Josh Devine, who was appointed by President Trump in 2025 to serve as a district court judge for the Eastern and Western Districts of Missouri. Prior to joining the bench, Judge Devine served as Solicitor General of Missouri, where he oversaw the office's appellate and special litigation division. As Solicitor General, Judge Devine led Missouri's trial and appellate teams to some of its most significant victories, including blocking $700 billion in student loan bailouts attempted by the federal government, obtaining a $25 billion judgment against China for antitrust violations, successfully defending the Missouri law prohibiting gender transition interventions for minors, making Missouri the only state in the nation to prevail at trial against an equal protection challenge to one of these laws. In addition, Judge Devine's work at the trial court in Missouri v. Biden helped expose systemic violations of the First Amendment, finding the federal government pressured social media companies to suppress millions of free speech posts. Judge Devine was previously chief counsel to the U.S. Senator Josh Hawley, where he oversaw all legal issues, managed matters related to the Judiciary Committee, and developed tech policy. Judge Devine clerked on the 11th Circuit for Judge Pryor and on the Supreme Court for Justice Thomas. He received a JD from Yale Law School and a Bachelor of Science degree in mathematics from the University of Northern Colorado. On the affirmative is Professor Paul Smith, who is a professor of practice at Georgetown Law and also vice president for litigation and strategy at the Campaign Legal Center. Until 2017, he was a partner at Jenner & Block. He had an active appellate practice for several decades, including oral argument in 21 Supreme Court cases in a wide range emphasizing civil rights and civil liberties. Among his most important wins were Lawrence versus Texas, the landmark gay rights case, and Brown versus Entertainment Merchants Association, establishing the First Amendment rights of those who produce and sell video games. Professor Smith also argued a long list of voting rights cases before the Supreme Court. The National Law Journal named him one of the decade's most influential lawyers, and the ABA section on civil rights and social justice gave him its prestigious Thurgood Marshall Award for his work promoting civil rights and civil liberties. He has won similar awards from the American Constitution Society, the DC Bar, and the Legal Aid Society of DC. On the negative is Hans von Spakovsky. He is an authority on a wide range of issues, including civil rights, civil justice, the First Amendment, immigration, the rule of law, and government reform, as senior legal fellow in the Heritage Foundation's Edwin Meese Center for Legal and Judicial Studies. He is the host of the weekly Heritage Legal podcast, and President Trump appointed him to the Presidential Advisory Commission on Election Integrity in 2017. Before joining Heritage in 2008, von Spakovsky served 2 years as a member of the Federal Election Commission. A graduate of Vanderbilt University School of Law, von Spakovsky received a bachelor degree from the Massachusetts Institute of Technology. With that, I welcome tonight's debate.
Well, thank you for that introduction. Good evening, everybody. It's an honor and pleasure to be here, returning for a second year for me to the Daniel Webster debate. Last time I was here, I was not here as a moderator. I debated the future of social media regulation, things like net choice, the TikTok cases, those sorts of issues. And since we so clearly solved that problem, I was invited back as a moderator to focus tonight on another easy issue, another easy, non-contentious issue that is definitely not making the news on a daily basis. And as your judicial moderator, I'm excited to be the one asking the questions. I'm thrilled, in fact, to see this series thriving. I'm the youngest federal judge right now, which means I'm I was both old enough to see and witness a very, very good, prosperous free speech culture on campus when I was in college. But I'm also young enough to have witnessed some of those cracks that started to develop toward the end of my college time and as I was entering law school. And the culture with respect to free speech has undoubtedly become worse over the last decade. I think obviously this culminated a month ago with the assassination of Charlie Kirk for doing nothing other than speak his views on college campuses. And I hope one day we will be able to look back at that horrific event as a horrible aberration and not as an inflection point foreshadowing things to come. And if we are able to look back at that horrible event as an aberration, it will be because of institutions like this, institutions that are working and continuing to work hard to build a thriving free speech culture, one where individuals can come to the table and debate very serious, very contentious issues in a very civil way. And so I'm very grateful for this organization. I hope student organizations like this one will continue to work to build that free speech culture. Tonight, our resolution is, should courts adjudicate partisan gerrymandering? And let me start by setting the scene. Let's say there's a governor of a state appalled by the actions of the opposite political party. And so he moves to redraw the state's legislative districts. Districts that formerly traced county boundaries become twisted into unnatural shapes, denounced by opponents as carvings and manglings. And let's say the governor acknowledges that this whole project is what you might say to be exceedingly disagreeable. But he also thinks that the turmoil of national politics and growing animosity between the major parties justifies this sort of exceedingly disagreeable response. And then let's say this redistricting bill becomes law, and it works by cracking a political stronghold of the opposing party and drawing very oddly shaped districts. The governor's party picks up several critical seats in the legislature. I'm, of course, referring not to North Carolina, Texas, California, Maryland, or Illinois, or any other states right now, but instead to Governor Elbridge Gerry of the Democratic Republicans in 1812 Massachusetts. Noting that one lopsided district looked like a salamander, Gerry's political opponents dubbed the redistricting a Gerrymander. So I think we may have been mispronouncing that for quite some time. Now, Gerry's decision did give the Democratic Republicans a larger legislative majority, even though the Federalists, the opposite party, actually got more votes. Now, ironically, another person elected that same year from that same state was the person for whom this debate series is named after, Daniel Webster, who won his first election to the U.S. House of Representatives in 1812 from Massachusetts. Now, obviously, this issue remains live today. Republicans have accused Democrats of gerrymandering states like Illinois and Maryland. Democrats have accused Republicans of gerrymandering states like North Carolina and Wisconsin. And many Republican states are now pushing openly partisan redistricting efforts, and many Democratic states like California and others are considering also redistricting for expressly partisan reasons. Each side will tell you who's retaliating against whom. And even some organizations that in the last decade opposed gerrymandering, organizations like Common Cause and some of those other anti-gerrymandering organizations, now actively support the retaliatory gerrymanders that we're starting to see. I'll discuss two cases that are relevant to our debate. And fortunately, Professor Smith served as counsel in both of those, and so he can correct me. He can correct me if I get something wrong. First is the case of Vieth, or Vieth, I'm not sure how to pronounce it. And in that case, Pennsylvania voters came to court and they sued to stop the drawing of a new map. And 4 justices there said, this is not going to be justiciable. Congress expressly gave the state legislatures control over over the districting process. And Congress also has kind of a veto over the state legislatures. Congress can pass its own laws to change these kinds of situations. And so those 4 justices said, this is supposed to be a political process that's clear in the text of the Constitution. Justice Kennedy was unwilling to shut the door fully on this. He agreed that nobody had been able to identify any cognizable standard to assess gerrymandering claims, how much gerrymandering is too much. But he thought we should leave the door open to this. He cited the 14th Amendment and said, well, the 14th Amendment has some kind of, some vague language, and we have all kinds of robust doctrines coming out of the 14th Amendment. Maybe we'll get something for this too. Court comes back to the question in a 2019 case, Rucho against Common Cause. And in that case, North Carolina and Maryland voters challenged their state's maps. And in both the district courts, they even prevailed. But the court, now with slightly different membership, reversed. The Chief Justice's opinion of the court basically adopted the same approach that the four-justice plurality had said in the Vieth case and said partisan gerrymandering is nothing new, even though frustration with it has extended for 200 years. And he went on and again said the same things that were said in Vieth, that the whole thing was given to the political process. If we interfered here, it would essentially countermand the framers' decision to entrust districting to the political entities. And Justice Kagan, in dissent, blasted this opinion. She said partisan gerrymanders deprive citizens of the most fundamental of their constitutional rights. It promotes partisanship above respect of the popular will. And although gerrymandering may have been around for a long time, the surgical precision by which it's done with computers and extraordinary amounts of data that obviously did not exist in 1812 is brand new. Now, I'll leave it to our debaters now to convince you who among the justices got it right and whether Rucho should be redlined out of their U.S. reports. I now recognize Professor Paul Smith for his opening remarks.
Thank you, Judge. The issue of whether the gerrymander should be adjudicated really does have two separate aspects that I need to address separately. One is the action of gerrymandering a map on purpose constitutional or unconstitutional? I say it's unconstitutional. In fact, I think that's not a very difficult question to analyze. The more complicated question is the one that was addressed in all the cases cited by the judge, which is this a kind of constitutional violation that the courts can do something about? Or is it instead a kind of violation where we can't figure out a justiciable standard and therefore we're going to wash our hands of it and let the politicians try to take care of it? First, on the question of whether it's constitutional, what is a gerrymander? It's a law. The map is a law. It's passed by the state legislature with the express purpose and effect of making some people's votes count more than other people's votes based on whether they belong to the right political party and support the right candidates or the wrong party and the wrong candidates. The effect of a gerrymander is to help some people translate votes into effective representation and hurt other people's chances of doing the exact same thing, even if they have the same number of votes cast on their side. It wastes some votes. It augments the power of other votes. It is, in effect, the same constitutionally equivalent as giving the Democrats 2 votes each to cast and the Republicans only 1. Does the same thing. I don't think there's a serious argument that the government should be in the business of intentionally trying to pick winners and losers in the democratic process based on their political point of view. It's a violation of the 14th Amendment. It's a violation of the First Amendment. Indeed, I don't know of a single justice in the last 25 years who's argued that it's constitutional. In Vieth, all 9 agreed that it was unconstitutional. It's really this issue of justiciability. Let me just mention 2 other things about the constitutionality. Sometimes a gerrymander could be so effective that it effectively decides who's going to control the legislature for the entire time the map is in effect. Wisconsin legislature was such a map. Gerrymandered in 2011, it effectively guaranteed Republicans 62 or 63% of the seats in the assembly. Didn't matter one whit whether it was a year where there was a blue wave or a red wave, the number didn't vary. The map had already decided who was going to get a supermajority of control in the legislature, and that's just not democratic. Now, Hans is going to mention the argument that there's no right to proportional representation. And that is certainly true. Whenever you have single member first past the post districts, there are going to be some years where the close races all go one way and one party does better, some years where the close races go the other way. You don't always get a proportional outcome between the votes cast and the seats won. But that's very different from saying that the government should be in the business of trying to completely disconnect how people vote from who gets elected. That's effectively what an extreme gerrymander does. It makes the election irrelevant to who controls the legislature, who controls the congressional delegation. And that's certainly not something that we should tolerate constitutionally. Now, on justiciability, the argument is, and what was accepted by 5 justices in Rucho, that this claim is one where you can't draw a line between permissible amounts of okay political finagling at the margins, which we tolerate, and more extreme forms of political bias that are being introduced. And that since you can't draw the line between them, there is an absence of manageable standards, to use the language for Baker versus Carr, and this becomes a political question the courts can't handle. The answer to this argument, I've always said, is to paraphrase Chief Justice Roberts, the way to draw a line is to draw a line. There are many quantitative measures for the degree of bias in a gerrymander. My favorite is called the efficiency gap. It gives you a number, a percentage, which compares the way that each of the parties' votes are wasted by the map, and how many more votes are wasted for one party rather than the other. And it's a measure of the degree of bias introduced into the map. If you want to draw a line, you just say any map with more than X percent on the efficiency gap scale goes too far. Now, maybe you think that's an awkward thing to do in a constitutional case, to draw that kind of a line, but the courts does that a lot. Look at the one person, one vote cases. There they had to decide how equal do the districts have to be to avoid being unconstitutional under the Equal Protection Clause. And the court developed the 10% rule in state legislative maps. If the biggest district and the smallest district are within 10 percentage points of each other, the map is presumed constitutional. If they're within 11 percentage points of each other, the map is presumed unconstitutional. They pull that number out of the air because they need a line. And the same thing is true here. I would only add that if you think that's an awkward thing for courts to do enforcing the Constitution, it's an easy thing for Congress to do. And there have been bills proposed in Congress, one almost passed a couple of years ago, to establish an actionable claim to enforce against gerrymanders using the efficiency gap or some other quantitative measure. And I only hope that if the courts continue to allow this kind of thing to go on, Congress will eventually be persuaded to do something. As the judge indicated, our democracy now is being completely debased by a race to the bottom. Both parties throwing out all of the work that's been done over the last 25 years to minimize gerrymandering and make democracy less effective, less meaningful, to take power from the voters and give it to the politicians in blue states, in red states. And I think it's an unfortunate, indeed a disgraceful situation, and we shouldn't tolerate it.
Thank you, Professor Smith. Mr. Spakovsky.
Well, first of all, I want to thank the Federalist Society for inviting me. Dennis, when I saw your last name ends with SKY, I knew I had to accept. Right? Before I start my presentation, I do want to make sure that people knew about the internship program at the Heritage Foundation. We hire a lot of interns. It's both we have a summer program, fall and winter. It does have a very early application date. So if you're interested, I'd urge you to apply for it. I can tell you the Legal Center hires anywhere between 4 to 6 interns, and they do real work. I've heard people in congressional internships complain that, well, they go get coffee and make photocopies. That doesn't happen. We use our interns to do work, write joint op-eds with us, do research and papers. So I'd urge you to apply if you're interested. Oh, and we actually pay a lot of government internships. I also want to echo what the judge said, which is to thank the Federalist Society for upholding a great American tradition. And that has virtually disappeared from a lot of college campuses, including law schools. And that's the ability to have civil, even vigorous, but polite debate and discussion of controversial issues. I applaud FedSoc for not bowing to the heckler's veto, particularly at law school, where you're supposedly being taught to make cogent arguments on behalf of your clients in court, and where if you were to shout down your opponent, that would not only get you thrown out of court, you'd probably be cited for contempt, and you might be disbarred, and most importantly, your client would lose their case. So I want to thank everybody for that. I actually think the Supreme Court got it exactly right in 2019 in Rucho versus Common Cause when they said that partisan gerrymandering is a political question beyond the reach of the federal courts. I also don't think it's unconstitutional. If it were unconstitutional, why in the world would the framers at the convention have handed the power to do it over to state legislatures? Because as the court pointed out in the majority opinion by the Chief Justice, this was well familiar to the framers during the colonial time. The judge gave you the history of where the word gerrymander came from, but actually, I thought it was kind of interesting. The first time I think that they've been able to track that it was used was in a political cartoon in 1812 in the Boston Gazette. So whoever that cartoonist was will live forever because he put that into a cartoon. Now, the Supreme Court's decision should not come as no surprise because of the same view they had in 2004 in the other case that Professor Smith was in, which was the Wyeth versus Jubileer case. The most important thing I think for you all to understand is that partisan gerrymandering is inevitable in a republic. You know, partisanship is considered a dirty word these days, but it's defined. What is partisanship? Well, it reflects the views and opinions that individuals and political parties have about history, culture, society, politics, and government. Imposing a rule that those interests can't be taken into account by legislators, the interests of the voters who supported them, chose them, voted them into office, when drawing political districts, I actually think damages a very fundamental part of the democratic process. And what's being proposed by folks is to come up with what I think I should trademark this, the Goldilocks rules of redistricting. You know, the idea that you can take politics entirely out of redistricting is just not practical. So supposedly we're supposed to come up with the Goldilocks rule. Well, too much politics is wrong and unconstitutional. Well, how little politics is okay? You know, if in the last election, one party in the state, their statewide candidate got 60% of the vote, and the other candidate got 40%. Well, does that mean that they get 60% of the legislative seats? Or do they get 70? Is it 70-30? Is it 60-40? How far can they go before supposedly it's unconstitutional? And you want judges to make that determination rather than the representatives who've been elected by voters? Voters who, you know, if they don't like what a particular legislator has done, certainly with regard to the federal courts, they can actually work in the political system to try to get that person out of office. Whether it's an election, putting up someone to challenge them in their own political primary, whether it's in a recall election, can't do that with a federal judge who acts politically to determine what all the political districts in a particular state should be. And I'm sorry, but these inevitably comes down to proportional representation. The argument always is, well, this particular party in a statewide election got, like I said, 60% of the vote. Therefore, they're entitled to 60% of the seats. But the Equal Protection Clause, the one person, one vote standard, applies to individuals, not to their political parties. And in fact, the court in one of the cases specifically said that it doesn't follow that saying that each person must have an equal say in the election of representatives means that a person is entitled to have his political party achieve representation equal to its share of the statewide vote. What you're saying is that judges should be in a position to say who deserves more seats and less seats than others And I just don't think that that's something that we should give, particularly to unelected federal judges, because decisions by judges on what's fair in the political realm would be, to quote the court, an unmoored determination of the sort characteristic of a political question beyond the competence of the federal courts. And all these solutions, these supposed equations like the efficiency gap, you know what they don't take into account? They look at voters as if they are they always vote the same way. That is just not the case at all. If you look at the history of American politics, you look at the history of American voting, a lot of Americans split their vote. There are a lot of places where they may vote for a Democrat in local races because they know that person, they like them. But for the statewide race, maybe for the presidential race, they vote for president. What are we supposed to do in the state of Georgia, where Georgia is represented by 2 Democratic U.S. senators, but Donald Trump won the 2024 election? Which party is supposed to get the majority of the seats in the state legislature? And what are we supposed to do? Redistrict every 2 years, every 4 years? Pennsylvania, Georgia, Wisconsin. In 2020, Democrats won the statewide vote for president. In 2024, the Republicans won the statewide vote for president. How in the world do you figure out, well, which party deserves a certain number of seats in the state legislature? Opponents don't like the idea that putting in strict standards would potentially actually solve this problem. If you want to have less gerrymandering, then put in standards, either the state legislatures through state laws or through Congress, because Congress is the one that can solve this under the Constitution, that put in strict rules for compactness, contiguousness, not breaking up towns and cities and counties, not going across physical barriers. A lot of opponents of this don't like this idea because it would prevent them from drawing crazy district lines that keep together so-called communities of interest, which is the code word for classifying voters by race and basing redistricting on the morally repugnant assumption that your race determines how you're going to vote. I'm sorry, how much time do I have?
Another 30 seconds. if
30
you wanna
seconds.
Finish something up.
Okay. The one thing I would tell you at the end of this is I so often hear people say, oh, well, if we can just stop this partisan gerrymandering, then in Congress and state legislatures, everybody will get along better, right? We won't have the kind of partisan fights that we have now. Well, we actually have a legislative body in the United States in which there is zero gerrymandering. It's called the United States Senate. And so I would leave you with the question of, do you think that the United States Senate has less partisanship, less political infighting than other legislative bodies like the U.S. House? If you think the answer to that is yes, well, then you probably think courts ought to get into partisan gerrymandering and we should stop doing it. But if you think that's going to solve our political problems, forget it. The reason we have this kind of fighting is because there is a deeper division about issues in this country today than we have had, I think, since the 1850s. Thanks.
Thank you. Professor, I'll recognize you for 2 minutes of rebuttal, and then I'll recognize you for 2 minutes of, I guess, sir rebuttal.
Thanks, Judge. First of all, 3 points. First of all, I didn't hear any argument explaining how it could possibly be true that it's a legitimate basis for governmental action, legislation, to try to augment the voting power of some people and decrease the voting power of other people because the government agrees with some people's political point of view and disagrees with others. That is just not a legitimate basis for government action. Mr. Spakovsky says, well, if you don't like the law they passed, the gerrymander they put in, work hard to get them out of office. Of course, the whole point of the gerrymander is to make it impossible to get that party out of control of the government. And we saw that in Wisconsin. It was impossible for the Democrats, no matter how hard they worked and how blue a year it was, for them to even make a dent in the representation, the supermajority in the Wisconsin Assembly, because that's the way it was intended to function. But most of all, I want to say something about proportional representation. Of course, it is true that those of us who complain about gerrymanders are saying there should be some connection, some rough proportion between the way people vote and who gets elected. And to say that should not be a very controversial proposition. To say that there shouldn't be any connection between how people vote and who gets elected is kind of a bizarre thing to say. But that's what Chief Justice Roberts said in Rucho. It said, I don't think you have any right to have anything like proportionality. What does that mean? It means that you might as well not have the voting at all, because if there's no connection between the preferences of the voters and who wins, at least roughly, then it's not a functioning democracy or republic, whichever term you prefer. And so there has to be, in order for democracy to make any sense, at least some limit on how much the government can work hard to make votes irrelevant and to decide in advance who's going to control the government.
Thank you. Mr. Spakovsky?
Well, I just disagree with that.
There's a surprise.
If 5-3 corresponds to statewide totals, is 6-2 okay? Can legislators engage in a little partisanship? How are you supposed to come up with a standard for how much politics can go into any kind of redistricting process? I actually think we should be much more concerned with something I never hear from the other side when I'm debating this, which is the fact that if you want to talk about vote dilution and manipulation of the political process, particularly representation, then we should talk about the fact that apportionment now includes huge numbers of aliens, and therefore states that make themselves sanctuary policies and do everything they can to attract aliens to their states, particularly illegal aliens, have more representation in Congress than they should. And when total population is used in the redistricting process, you are diluting the votes of U.S. citizens, no matter their race and no matter which political party they represent or affiliate with. And that is a very, very big problem. And anytime anyone wants to solve that, the same individuals pushing this, an organization pushing this, are very much against basing redistricting on citizen population, the individuals who have the right to participate in our democratic process.
Okay, thank you. I've got a number of questions for each of you. What I'm going to do is I'm going to ask you the question that I've arrived at for you, give you an opportunity to answer, and then allow the other individual a very short period of time to reply, rebut whatever you said. So my first question is for Mr. Smith. You talked about the efficiency gap.
Mm-hmm.
This idea, and correct me if I'm wrong, but this idea that, you know, the more the greater the number of votes above 50%, the more votes have essentially been wasted with respect to this race. And I guess my question with respect to that is, of course, you know, 50% plus one is what you need to get the electoral victory. But isn't it also the case that you get a political victory from a blowout win? Isn't it the case that Lyndon Johnson got a political victory from his blowout win over Goldwater, in which would not have been the same had it been a very tight election?
Well, that's true if you're running a national race, but if you're running a district race trying to carry a legislature, a blowout win is the last thing you want to have. You're wasting a lot of the votes on your side that would have been more effectively used by being spread out more efficiently into other districts. Packing and cracking is how you do gerrymandering. And if you're a Democrat, the last thing you want is an 80-20 Democratic district. It just doesn't help you achieve your objective.
Now, that's certainly true for the party as a whole, as an apparatus, but for the individual legislator, doesn't the individual legislator want to win by a bunch?
Well, sure, anybody likes to win and have a district that's easy to run in. They don't have to run in, but gerrymandering is done by parties. It's not done by individuals for the advantage of the party. to help them control the legislature regardless of the views expressed by the people when they go into the voting booth. And so what the efficiency gap does is it counts all those votes above 50%. It also counts all the votes in all the districts the party loses, because those votes they don't get any representation for either. And so it's just a measure of packing and cracking, disparate packing and cracking. And everybody knows that's how you do it. It's not like it's not very complicated, frankly. The complicated part is predicting how people are going to vote, which they've gotten pretty good at, despite what Hans says. But people have become pretty polarized and predictable in their voting behaviors. And so I think the basic concept of the efficiency gap works pretty well, Judge.
Any response to that?
The efficiency gap test is not based on reality. Let me tell you why I say that. You know, the idea with the efficiency gap is if you put more than 51%, let's say, 57 plus one of votes who are going to vote for a particular party in one district, well, everything above that's a waste. And therefore, you're engaging in partisan gerrymandering. Well, the problem with that is turnout rates vary greatly. They don't just vary from state to state. They vary from different parts of different states, and they vary from election to election. You can have extremely low turnout in local elections, and then you may have very high turnout in presidential elections, somewhere in between with congressional elections. Well, if you're using an efficiency gap to judges, this test, and it's all based on, okay, anything above 51%. Well, are you going to always get the kind of results you want to support a particular political party when turnout rates vary so greatly, and that 51% may work sometimes and not work other times? Again, it's just an unworkable and an impractical standard.
All right, Mr. Spakovsky, I've got a question for you, and I'm going to set it up by talking a little bit about the tiers of scrutiny. So everybody's familiar with the tiers of scrutiny, strict scrutiny, intermediate scrutiny, et cetera. And Justice Scalia quite famously said, yeah, these things are totally made up. They come from, a New Deal era opinion, but we judges, we need some kind of standard by which to measure things. So yes, this is a judicially created standard, but we need some kind of standard. So I guess my question for you, Mr. Spakovsky, is if they can do that for the tiers of scrutiny, and I know there's some debates with some scholars who are saying they shouldn't, but if they can do that with the tiers of scrutiny, then why not for something like this? Why not, as Professor Smith says, come up with a number and then measure based on deviation from that number?
Because I don't think you can get disagreement on that number. Look, it's easy to come up with an equal protection review on vote dilution when the easy number is, as you know, the Supreme Court has said, for example, with congressional districts, those populations have to be as even as possible. You know, if the standard population for congressional district is 100,000 voters in a state, if you make one with 100,000 and the next one has 100,100 voters, you're potentially going to have a problem. That's a very straightforward standard, as equal population as possible. But trying to come up with, well, how much politics is going to be okay? How little politics can be used? Where are you going to come up with a standard that is as exact as the one for equal protection when it comes to districts have to being as equal as possible? I just don't think you can do that.
Professor Smith, any response?
Well, constitutional law is full of rules that the court has to make up to try to give meaning to the basic principles of the Constitution. Tiers of scrutiny, the 10% safe harbor for equal population in state legislative maps is not, it's quite different from the rule for congressional. It gives a substantial amount of leeway to have bigger districts and smaller districts. All of that is completely made up by the court. It's been around for 40 years. And there's no reason to criticize them for that rule. It's a perfectly fine rule. They have to have a rule in order to enforce one person, one vote, decide how strictly they're going to enforce it. And the same should be true as to gerrymandering. It's indistinguishable as a matter of principle.
Any response to the argument that the one person, one vote thresholds are made up? So for example, there's a case Either the Vieth case or the Rucho's case cites Gardner against Cummings, which is a case arising out of Connecticut, where the Supreme Court allows districts that vary even up to 15 to 20%. And so you don't have one district with 100,000, another with 100,001. You've got one district with 100,000 and another district with 85,000. So I guess what's the response to that, Mr. Spakovsky? If the court can do this in the one person, one vote area, why not in the gerrymandering area?
I think the difference there is they only allow that variation so that a state can comply with traditional redistricting standards. The things I mentioned before: compactness, contiguousness, not breaking up county, not crossing county lines. That's what allows the variation. And the courts have, on more than one occasion, when there's been that kind of a variation that cannot be tied to trying to comply with those kind of standards, said, well, you may be within the 10%, but you've still violated the law. And the best example of this I can give you is the state of Georgia. That when the Georgia state legislature was still controlled entirely by Democrats, they did a redistricting of their state legislature in which they kept within that 10% variation. But they didn't do it to comply with the kind of standards that I'm talking about. What they did was, in order to keep their political power, they systematically underpopulated Democratic districts and systematically overpopulated Republican districts, still staying within that 10% variation. And the court said, well, you may have stayed within that variation, which we normally allow, but you didn't tie it into any kind of standard that applies under the law. And they said that, and they threw that redistricting out. And that's the situation, I think, that we're talking about here.
In your response, Professor Smith?
Well, sure. There's an exception to the 10% safe harbor. It's presumptive. It's not conclusive. There was one exception in the history that I'm aware of, which is the one that Hans was talking about, where it was abused. But that's not an answer to the basic point I'm making, which is the 10% rule is a rule the court constructed for itself, essentially out of thin air, to try to give meaning to the Constitution. And that's not unusual. It's the way the court operates.
Question for you, Professor Smith. The majority in Rucho and the plurality in Vieth both seem to take as a given that there is going to be politics in the process. Politics is inherent in the process. Some amount is. And so their concern is, well, we don't know how to measure how much is too much politics. So I guess my question for you is, what kind of political considerations are appropriate? Like, can Louisiana redistrict to save the Speaker of the House?
I think they can, yes. The court's instinct about this has always been that the framers gave this job to politicians, and it's silly to expect them to be completely blind to the political consequences of what they're doing. First of all, they're going to know what they're doing because they're the politicians. And second of all, if they're drawing their own lines, they're not going to be completely without some thought about this. And so there's a willingness to tolerate a certain amount of politics in the process. That's what creates the line drawing problem that we've been talking about tonight, but it doesn't make the line drawing problem insoluble. At some point, you go from just the politicians helping themselves a little bit here and a little bit there to a district map that effectively makes the democracy ridiculous, makes it not work anymore. And you have to have a test by which you can distinguish between those two things once you allow us to tolerate a little bit of politics in the process. And that's what the quantitative tests that are out there do very easily. The efficiency gap's a good one. There's also the use of thousands of random maps that show you how far off from a neutral map, the one that was drawn by the state is. There was discussion of that in Justice Kagan's dissent in Rucho. There are lots of ways to do it. But the fact that there's a line drawing problem doesn't mean you can't draw the line.
Any response?
You're once again injecting judges into determining how much politics is enough and how much isn't. It's one thing to analyze a redistricting map and to look at how much it varies from the equal population requirement under the Equal Protection Clause. It's quite another to be looking at it and saying, well, yeah, their populations are equal, but there was too much politics that went into this. And, you know, the idea that when districts are gerrymandered, they'll never change. Again, that is not reflective of our political history. Our political history is filled with individuals who were in what they consider to be safe gerrymandered districts that were defeated. And probably one of the best examples, I hate to go back to Georgia, but the man who holds the Guinness Book of World Records for being the Speaker of a state house for the longest period in American history, and Paul, you probably knew him personally, Tom Murphy, Democrat in the Georgia State House, everyone thought he could never be defeated. He had this perfectly safe district, and to the great astonishment of the entire state and certainly Tom Murphy, he was knocked off by a young guy about y'all's age in his mid to late 20s in a race where he spent very little money but managed to knock off the Speaker of the Georgia House. And that is just one of many examples of that happening. So the idea that if districts are gerrymandered, those individuals are always going to be safe, no one's ever going to be able to challenge them or defeat them, that just doesn't match our political history.
All right, I'm going to open it up to audience questioning at this point. Yes.
One line based on your efficient standard, is that a form of gerrymandering on the opposite spectrum? Because it's quite natural that you're gonna, as far as I understand,
Form of gerrymandering off the spectrum.
on the opposite side.
Oh.
Right, where it's still partisan gerrymandering sense, where you're naturally going to have very packed districts like cities that are full of blue voters, and then, you know, outside those districts, you're not gonna have a lot of blue voters. So those city areas are all, you know, naturally gonna have a lot of wasted votes.
I agree that if you are going to construct a rule and you take seriously the problem, and I don't think that the majority of the justices do that or even want to, you'll have to also figure out how you handle differences of geography that are sort of natural gerrymanders, like the Democrats packing themselves into cities. And you could have a rule either way. Either you should ignore that and fix it, or you could say that can explain a higher efficiency gap or something like that. Those are the kinds of things you'd have to take into account if you were going to have a functioning rule. And it was one that Chief Justice mentioned in Rucho, actually, that do we accept the fact that people are not evenly spread out, or do we have to compensate for it? And it's a question they'd have to answer, but they haven't asked the question, so they don't have to answer.
I mean, the only thing I would say is that this efficiency gap causes exactly what you were talking about, which is because so many, for example, Democratic voters pack into cities, they have a geographic gerrymandering problem. The only way they can disperse that is to stretch these districts way out of these cities, and that's when you get the kind of districts that, for example, in the Reno versus Shaw decision, when the Supreme Court threw out a district in the Carolinas that had been drawn, it looked like a dumbbell. You know, it took two opposite ends of the state, and what was in between them was the interstate highway. And you're going to get even more of that. And I don't think we should be drawing districts that, as a person I know who was running out of Georgia once told me, he needed a GPS unit to be able to figure out whether he was in his district or not. And I think that won't happen if we really emphasize the kind of standards that I keep talking about.
Well, it is happening, right? I mean, it's happening every day, all over the country right now. The districts that are being drawn by these legislatures in the last 2 or 3 weeks are horrific. And it's because they're trying to maximize gerrymandering. Sorry.
This is what a debate is, right?
All right.
Yeah.
Well, fine. You want to fix that?
Yeah,
get Congress
worked
to,
for it.
get Congress to pass laws on compactness, contiguousness, et cetera. Don't have the courts create some standard out of whole cloth and have unelected federal judges getting into drawing up, here's what all the congressional districts are going to be. Here's what all the state legislative districts are going to be in a particular state. The judge, I'm going to determine the politics of this state and which political party gets control of this state.
At least at the congressional level. So setting aside state legislative seats, but for seats in Congress, is part of this Congress's fault because they passed a statute saying we're going to have single member districts instead of multi-member districts?
And because they failed to pass a statute that says we're going to have a limit on partisan gerrymander, which they very nearly did in 2022, the Freedom to Vote Act would have fixed this problem for Congress. But yeah, no, the fact that we have single member districts is a feature of what makes partisan gerrymandering effective. If you had multi-member districts and they were bigger, it would be less easy to manipulate. It might have other bad effects like submerging people in a bigger district where one party gets 5 seats out of. But that is a proposal a number of people have made to try to limit gerrymandering.
Other questions from the audience? Yes, in the back.
Well, I wish I was professor, but I'm not. Or maybe I don't wish I was professor.
It's a tough job, actually.
Based on the fact that partisanship is sort of an arbitrary measure, and next election, a seat that was safe won't be safe, a seat that was not safe will be safe. But is that not also true of population?
Of what?
Population, that the population of districts 2029, many districts will be added, proportional, one person, one vote. Is there a reason why, in a similar vein to when we say every 10 years arbitrarily, you don't meet the standard, why every 10 years we say, the partisanship?
You bring up an important issue, which is most states usually redistrict once, right? It's a year or two after the census. So that means by the time the next census is rolling around, the districts they've drafted, that they've drawn are way out of proportion. There's no way they have equal populations anymore because Americans, society, we have one of the highest mobility rates of any of the Western democracies. But the courts have never come back and said, Supreme Court certainly hasn't, that well, you have to redistrict in 5 years because the population is so unequal. They just kind of accept this as a potential problem that right now is not solvable because we only have a census every 10 years. Actually, what's kind of interesting is that a number of years ago, Congress actually amended the U.S. Census statute to direct the census to do a census mid-year. I mean, 5 years in between the censuses, but they never appropriated the money for it and they never got around to doing it. If they did, we probably would see redistricting much more often. The other thing to keep in mind is that there have been lawsuits filed against midterm redistricting, claiming that that was unlawful, and the courts have thrown that out and said, no, it's not. By the way, one solution to this too, and I'll be quiet. I actually wrote a paper about 6 months ago recommending that states start doing what about 3/4 of the states did in their first 100 years of our history, which is to do their own census. They could hopefully get more accurate information than the federal census, and they might do it more often than once every 10 years.
Further questions?
I think it's going to go to Adwin. So this argument, though, that by giving drawing of districts to the states, there's kind of like baking in partisan gerrymandering constitution seems to be. Like at the time of the founding, most of the fathers did not expect or even desire political parties and factions to rise. So I'm wondering if that, like, now that political parties are a proxy for people's political views, and therefore kind of allows discrimination on the basis of political views, like, should we take that back into account? Is it the case that the founders knew that what we were doing was creating like factional self-interest in gerrymandering?
They were probably more assuming that it would be individuals who would be manipulating the lines for their own personal benefit. They didn't really anticipate parties, but that's actually true. But it didn't take very long for them to appear, that's for sure.
It seems to be one of the bigger oversights in the
They just were
Constitution.
very naive in that one particular respect. Not
Well,
a word you use about the founding fathers very often.
Well, you say not particularly long. I mean, it was literally a couple of years before it happened.
I mean, I think their hope was overturning their common sense and their knowledge, because, you know, most of them somebody had come from England, they knew the political party fierce fights that went on in the English Parliament. So the idea that somehow we weren't going to get political parties was just completely unrealistic. And they may have said that, but I don't think any of them really deeply believed that that's what was going to happen.
One of the things that is true of the debates is they were concerned about England's tradition of having districts where there were no people. These sort of boroughs which existed for centuries because had like 3 people in them, and they were very aware of that as an abuse that needed to be avoided. So that's partly why they did the census and the redistricting every 10 years.
So one question is, it's kind of tempting to look at this issue from modern politics and the way the way the parties are framed today. There's an argument to be made that during much of the 20th century, you really had more like 4 political parties. You had a conservative wing of the Democratic Party, a liberal wing of the Democratic Party, and the same is true of the Republican Party. And so you end up with situations where Reagan wins 49 states, and yet there's a Democratic House. How much is our current conception of, the 2-party system rather than the, looser, maybe 4-party system affecting the conversation on this issue?
The polarization of the parties, with all of the Republicans being very conservative, all of the Democrats being more liberal, actually makes it easier to gerrymander because people's votes are predictable. You don't have the kind of massive ideological overlap you used to have between the 2 parties, as you rightly describe it, Judge. And I think that means that people are much less likely to go back and forth between the liberal Republican and the liberal Democrat, the conservative Republican, conservative Democrat. And so I think that the reality is people who have good computer data can predict with very good precision exactly how the districts are going to behave because we have lost that overlap.
Yeah, on the flip side, and I guess this might be for you, Mr. Spakovsky, the Republican Party quite sure looks a lot different than it did 12 years ago. How stable? I mean, is there a stability issue? I mean, maybe there's more polarization between the parties, but each of the parties might be a little less stable than they used to be. Is that any reaction to that?
Well, the reaction I'd have is look, to these days, depending on where you are, I think actually the Democrat and Republican parties both have less strength because there are so many independents now. In a lot of places, it's about a third, with some variation between those, which I think makes this whole gerrymandering issue, as I've said, even more difficult because independents tend to go back and forth between different candidates and in state, local, and federal elections. So I don't, while there are very fierce partisans in both of the political parties, I think the American people as a whole are less bound to those parties, and that's shown to me by the fact that people who consider themselves independents has grown so substantially in the last 20 years.
The voting behavior doesn't match that. It is true that people register as independents, but if you're analyzing how a district's going to function, you know what the Democratic performance is going to be and the Republican performance, because most of those independents are consistent Democratic voters or consistent Republican voters. That's just the reality. They just don't like to affiliate on the registration rolls.
Other questions from the audience? Yes.
partisan hustling over the drawing of far-fetched districts is the objection, and it seems like both sides object to it. It's just that they find them far-fetched in different ways. Is there a problem? Would there be a problem with identifying geographic compactness and contiguity requirements and having districts that are mostly stable, and basically letting the changes in the composition of our elected representatives have more to do with the ongoing discussions that citizens are having, how people are voting with their feet, as opposed to the redrawing maps? If I said
There's a bunch of different things in that question. One is that we wouldn't change the districts even when the population moves around.
I think what I'm trying to ask is, what would the problem be for either party with requirements for compactness and continuity that kept the districts largely the same?
Well, I mean, if the idea is that those two things strictly regulated will eliminate the possibility, it would make it impossible for people to do extreme partisan gerrymanders. Experience suggests otherwise. You can do compact districts. You just have to draw the lines in the right places. They don't all have to look like Shaw v. Reno districts to be partisan. And contiguity is already required. So that's sort of a given. It has been since the 1840s. There could be more or less, but it's basically in other words, compactness. But compactness alone isn't going to solve this problem.
Look, if you get out of here, Google Iowa and Google its districts. They have very strict rules there, and their districts look just like the squares that folks got for homesteading, you know, when they got 660 acres. The kind of crazy districts we see in other places, you don't see that in that state. And part of that is because of the very strict rules they've put in along the lines of what I've talked about.
Is part of that also that Des Moines is in the middle of the state?
Could be, yeah.
But also there's a nonpartisan commission that draws the congressional districts. I don't know if that's true of the legislative districts, but they don't have a partisan gerrymandering of congressional districts there. In fact, the people who draw those districts are not allowed to even know where the members of Congress live.
I guess a follow-up to the redistricting commission. I mean,
Yeah.
there's been the criticism that the redistricting commission is really just politics without being honest about it. These are all political actors, and they're just operating under the veneer of some nonpartisan operation. Any response to that?
Some of them are set up that way, where you have a certain number of Democrats, a certain number of Republicans, and they're there to represent their party, and maybe you have a tiebreaker. The ones that, like California, are not like that at all. They go through an enormous amount of effort to make sure they don't have politically active, politically aware people. And I think that most people would agree that that commission, which is now not going to be in effect for a while, produces maps that are not in favor of either party without an agenda. That commission prides itself on not doing that. So I think it's possible. Much depends on the details of how you set up the commission.
Well, I would agree. It depends on how you set up the commission. My problem with commissions is that they're not accountable to voters. In other words, look, you may not like the way your state legislators draw up maps, but there's a political process there for you to try to get them out of office, whether it's run somebody against them in their own political party or in the general election, a recall election. Well, you can't do any of that with a commission with appointed members who you can't do anything to get them out of office. And if you think the California Redistricting Commission doesn't engage in partisan gerrymandering, I'd refer you to an article that I wrote a couple of years ago with someone from the Capital Research Center, where we actually applied the there's this European test that they use in this area to determine gerrymandering, and we compared the California Redistricting Commission to the Republican-controlled legislature of Texas. And it turned out that the California Independent Redistricting Commission had drawn up more partisan districts than Texas had.
If they
You
did,
don't
they
have to
didn't.
believe me, you can read the article and look at the data itself.
If this is such a partisan gerrymandering, how come they could squeeze out 5 or 10 more districts as soon as they throw out their map? Now, obviously, it's not anywhere near as extreme a gerrymander as it could have been.
How about 60 seconds for any kind of closing remarks? We'll start with you, Professor Smith.
Well, I think the problem with these gerrymanders is that they take power away from the voters and give it to the politicians. And that's a problem that democracy needs to solve. Given that we use these single member winner take all districts, we can't tolerate just letting the politicians basically figure out a way to draw the lines so that they can tell the voters in advance who's going to control the government. That's the nature of the problem. There are solutions at hand. It's just somebody has to have the political will to do it. Unfortunately, the justices didn't.
There may be problems. We can all get frustrated with gerrymandering and the drawing of districts by the representatives elected by voters. But no matter how many problems that you may see in that, that's still better than districts being drawn up by unelected single judges for an entire state. Or that to me is the very essence of anti-democratic action.
Well, thank you. And please join me in thanking our speakers today.
Thank you, Doug.
Thank you all for coming. Our next debate will be Wednesday, November 12th on whether the court should continue to adhere to substantive due process. Thank you again.
21. Yeah, been a while. Had a lot of time. Graduating.